Well, thank you, Dawn, and thank you, everybody. It's a pleasure to be here, and it's an honor. And so, before we go any further, everybody, go ahead and just let's give Dawn a hand because I love. Let's use one of those emojis, the clapping hands, right? Because what Dawn has done has really just been awesome here, and we love working with
Thank you.
Protect Wealth and all of those things. So everybody give Dawn the clapping hands, the hearts, the smiley faces, whatever else on those emojis. So thank you again. It's
Thank you,
a
Jeff.
pleasure to be here. So as Don said, my name is Jeff Cottle. I'm one of the senior attorneys here at Anderson Business Advisors. And I'm going to talk about a couple of things here that may sound like review for a few of you, especially if you're longtime students of Don's, but I still want to discuss them so that we are operating with the same baseline knowledge, if that makes sense. Just as a quick anecdote related to that, so long ago as a child, I didn't know how to play speed or lightning on the basketball court, and I was so relieved when a PE teacher said, "I don't care if you know how to play this game or not. I'm going to review the rules for everyone so that we're all operating on the same page." And I was so relieved because I learned how to play. So we're going to apply that same principle here. The first few things that I will talk about will probably seem like review for a few of you, but it's important because it sets the stage, right? And it sets the table for the reason why statutory trusts exist, why we use them, and then how they can help us. And not just help us related to California franchise tax, but help us as we apply other tax strategies as well. So before I get into that, though, quick introduction to us as a law firm, Anderson Business Advisors. We are a law firm that specializes in asset protection, transactional work, estate planning, and tax planning for real estate investors and small business owners. We're sort of a one-stop shop. We do all of those things in-house. Yes, we literally have CPAs that work with us, and we literally have attorneys. I'm an attorney, right? That we work with as well. And so we all work together to put together these holistic plans and strategies. And yes, a bunch of the ideas that I'm going to talk about today did come from our CPA team or from our estate planning team or from us, the attorneys. It's really important to know that we all work together. As a quick housekeeping item, I do have the chat and the Q&A pulled up here on one of my other monitors. So if you have a question or if I haven't talked about something clearly or if you have something that you want to know more about, please send that over to the Q&A feature. Sorry, I'm gesturing at it. You obviously can't see it here on my screen, but use the Q&A feature or the chat to send in those questions because the odds are really good that if you have a question, one of your colleagues or friends here on the call also will have that same question. And so I want to make sure we talk about them as we're going forward. So please go ahead and send in your questions. I love when it feels more like a discussion. So go ahead and send those in as we go. And so one more thing before I jump in to the actual meat of the presentation. I am an attorney at Anderson Business Advisors. My quick background is that I came out of law school doing transactional business work. I worked with a more traditional transactional and litigation firm. We kind of did all of the above in a small town. We were the only business law firm in town, which was both great and awful. It was great because I learned a lot of new things, and it was also awful because I learned all of those things by being dropped into the deep end of the pool. So there were a lot of things that we had just not run into before as a small firm that the partner just kind of dropped on my desk and said, "Jeff, figure it out." And so I did. And it gave me a lot of important experience that now that I lean on a lot here working with Anderson Advisors. And so my background is in anything small business and contracts. Obviously, to work with Anderson, I have to know my real estate and my tax planning very well, and that's kind of the specialty that I've leaned into now here at Anderson. Is I do advanced structuring, I do advanced estate plans, and especially advanced tax planning. Those are the kind of things that I do here at Anderson now, and so it's a pleasure to be here. And so we already have a couple of questions here, and so I'm going to answer them just quick generally here, but then I'll set the table for why statutory trusts are so important and what they do. So Alper asks here, says, "Hey, how are statutory trusts treated for tax purposes?" That's a great question. And the answer is the way we form them, and this is very important, the way we form them, they are disregarded entities. And this is vital, and I'll get into this in a little bit more detail later, but it's really vital for the tax planning side of this that they are treated as disregarded entities. If we treat them as anything else besides disregarded entities, then we run a big risk of California charging the corporate tax rate, which actually ends up being more than that $800 per year. So if we have a statutory trust that, say, for example, is taxed as a partnership or taxed as a corporation, then we run the risk of California charging that $800 franchise tax and the corporate tax. The franchise tax may not still apply, but the corporate tax rate can really be killer there. So they're disregarded. And just for a quick, again, so that we're all on the same page, disregarded means that they do not, meaning these statutory trusts, do not file a tax return at all. All of the taxes are attributed to either the beneficiary or the owner there. In this case, in the way we set them up, the beneficiary will usually be an LLC, and say a Wyoming limited liability company, or LLC will be the beneficiary. And even further, if that LLC is disregarded, all the taxes might just flow through to your personal return, which is great. There's nothing wrong with that. We like it. And so that is how they're treated for tax purposes, the way we draft them and set them up. And we transfer real estate into a statutory trust using a deed. Deeds are the way that all real estate changes hands or is transferred. And so we would use a deed in that case to transfer something from somebody's personal name into a statutory trust. So to give a little bit more background here, again, we want to make sure that we're operating with the same definitions and the same reason that we're talking about what we are. I want to start with sort of a couple of baseline rules here. And so the first thing that you'll find out as you get to know me is that there is nothing I enjoy more than bashing on my own profession. I almost feel like an anti-hero in a comic book, in the sense that what I'm doing is I am an attorney who's trying to help you avoid other attorneys. And to be clear, I don't mean to say that every single attorney that exists is inherently evil or bad. No, most attorneys that you speak with on the street, or that you meet them in your neighborhoods, they'll be really pleasant to talk with and they'll be great. But it's just a matter of how the profession is now in general. That the profession does not rely on justice, equity, truth, and statutes and regulations and all those things, though those things matter sometimes. But so much more now, it is that money controls, and logistics control, and knowing people controls instead. And that's problematic, because then it turns into a game of not, for example, if we're talking about a plaintiff's attorney who is thinking about suing somebody, it's not a matter of, wow, this potential client came in, I wonder if they have a really good case. No, 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 no. The first thing a plaintiff's attorney asks is, wow, potential client came in. Are they suing anybody rich that will get me money? And so if you're a real estate investor or a business owner, then yeah, unfortunately, that puts a target on your back, whether or not you do anything wrong. And very frequently, it's that you have not done anything wrong, but that a plaintiff saw, or a potential plaintiff saw, that you own a lot of properties, or saw that you own a nice car. So they hire an attorney, and this attorney sort of stalks you online and is like, oh, wow, I wonder how much I can get out of them. And then they decide to file a lawsuit based on dollar figures and not based on whether somebody is right or wrong. And so this is problematic. And so then what I'll tell people is, we want to then leverage this to our advantage. Say, okay, so you want to play that game of money, or you want to play that game of logistics that matter more than actual merits in the courtroom, then we can leverage that game to your advantage. And we say, okay, let's go ahead and let's take your name off of the public records. And that's the first thing I'll tell any client of mine. And this is kind of where the first statutory trust sort of thing will come in, is there are certain scenarios where a statutory trust is incredibly, incredibly beneficial to be the entity into which you will place your assets, so that when somebody looks you up online on the county records, and to be sure, all real estate ownership is public record. In some places, it's easier to find than others, but it is public record. And so no attorney can look you up on public records. That's what we want, right? Or no plaintiff can look you up. And even if they can look you up, even if they do find you somehow, we want you to have that advantage in the courtroom. And so that's why I'll tell clients, the very first thing we want you to do before anything else is just not invest in your actual name. So instead, we may say, let's invest using a limited liability company. We'll get asked, why don't you use irrevocable trusts? Those have gained some, those, sort of go, they sort of go in waves back and forth in popularity in irrevocable trust. We don't usually recommend using an irrevocable trust. We recommend usually using a limited liability company or an LLC to get things started. And you'll notice even when we do use statutory trusts, we will still recommend having an LLC be that beneficiary. Why? Because LLCs have they have all sorts of protections in court that are established. Like we have judges, we have precedent, we have statutes that say that, hey, LLCs provide protection from lawsuits. So that's very important. And so that's the first thing I will say is, hey, if you're doing investing, don't do it in your own name, please. Invest using a business entity, usually an LLC, but we'll talk about where statutory trusts come in. And so we will use trusts for other things like estate planning. As I had a couple people ask there, is a statutory trust the same thing as a revocable living trust? The answer is no. They're used for very different things. A revocable living trust is a vital estate planning tool. It does not provide asset protection or usually tax planning. There are situations where it can help with tax planning, but not usually. So instead, what we would say is that the revocable living trust, its primary objective or purpose is to avoid probate. And it's hard for me to describe how important that is. Just to give a quick review, probate is the court-appointed or approved process by which a judge determines what happens with your assets after you pass away. To be sure, to give like a smidgen of credit, judges will usually try to find family members or relatives or descendants or whoever else that might be to give your assets to. However, that's the only nice thing I will ever say about probate, because probate is like all court-appointed processes, it's wildly expensive and extremely time-consuming. And very importantly, you don't control the process. And so if a probate happens, again, the judge will try to find descendants, but the judge will not, they will not follow your will or your desires. They will decide what happens. And so if we use a living trust, then you take control of that process. And unfortunately, it is a big factor, and people aren't fighting about your stuff. So what happened to my grandmother's estate is that my father and his siblings, my father tried to stay out of it to be sure, but his siblings, they all fought about what to do with the trust, hired their own attorneys, or what to do with the estate. They hired their own attorneys, and then lo and behold, the estate was all wasted on attorneys and court fees rather than actually ending up in the hands of any heirs. So the living trust helps avoid that. Somebody asked the good question then, well, then how come living trusts don't provide asset protection though? Protection from probate and asset protection are two different things, right? So we want to avoid probate and we want to have protection from lawsuits, but those are two separate things here. So in this case, revocable living trusts do not provide asset protection because you still retain 100% control and it's not considered a separate entity. And when we form a revocable living trust, you are the person who forms it. That's great. That's awesome. There's nothing wrong with that. You are the trustee. Also great. That's important because you retain control. And you, importantly, while you are still alive, you are also the beneficiary. And so if you retain complete control, we have a hard time arguing before a judge or against another attorney that, hey, these assets don't actually belong to me. They belong to somebody else. And that's the whole point of using an LLC. Here, let me skip back here for half a second. That's the whole point of using an LLC or a statutory trust. Importantly, again, we'll get there in a second, is that they are separate liability-wise because they are businesses. They're business entities. They're separate from you. So with the LLC, we have the claim, and rightfully so, to be sure, this is held up in court as long as you take care of it properly, that, for example, if you are in a car accident, you rear end somebody, no serious damage, but because you have a lot of assets, the plaintiff's attorney decides to come after you anyways. So if you rear end somebody and they want to come after you, you can then say, hey, I was involved in this car accident, but my LLC was not. Hooray! As long as we have a business purpose for those assets, we're looking good. And that business purpose can be important, but hey, rental property, you're making money, business purpose. Rental property, LLC was not in the car accident. I was. Rental property protected from the lawsuit, not going to be sued. Inverse is also true. Rental property, LLC is the owner of the property, not me or not you in this case, right? So then if it's a different entity, they don't sue, the tenant does not sue you. So then as we keep going through this process, then as we want that separation. And so a revocable living trust, different from a statutory trust, the revocable living trust then provides that avoidance of probate, right? In the sense that, hey, we don't have to deal with probate anymore, but it's going to be separate from the protection from lawsuits. And so in this case, this our friend here, Anonymous, has also asked and following up. So then would we put an LLC inside a revocable living trust? And the answer is yeah, we would. So the LLC then would not have to go through probate and could pass along to whoever you designate, children, fans, family members, whoever you decide to be your heirs. Yeah, it would absolutely pass along without needing to go through probate, the LLC itself, but we need both in this case. So great questions and great thoughts there. Doing very well so far. And Elvira asked a follow-up question here related to that hypothetical of the car accident. What if the car you drive belongs to the LLC? Then we're in trouble, because then the plaintiff can claim that the business was involved in the car accident. So we will usually, this is actually really funny because people will ask for tax benefits. Should I buy a car with an LLC? The answer is no. Almost always. There are a few exceptions to that, because there are exceptions to everything in the law, right? But it's because the LLC will, or because the car will bring liability with it to the LLC. So then what we have then instead is that the car brings liability. It increases your insurance rate. So no, keep the cars in your personal name for the most part, with rare exceptions. And that way we're not bringing liability to your LLC. So that's a great question though. So what happens then is that not all LLCs are created equal. And in this case, not all trusts are created equal as well. So I'm going to show you a quick, just really simplified sample structure here that we may put together for a client. And then what that will look like, and this will address one of the questions I see here as well, is what that will look like then is this will be very similar to what things will look like for our Wyoming statutory trust structuring. So if you look on the left-hand side of the screen here, you see that we have local LLCs. So this may be LLCs in an individual state that own real estate. They are owned by Wyoming LLC. To be sure, Wyoming is not the end-all be-all, but it usually ends up being Wyoming for real estate investing, at least. And the reason for this is because Wyoming just literally has awesome laws for asset protection. It's Wyoming, Nevada, and Delaware, sort of the big three for asset protection. Where Wyoming, it's actually really funny. It's funny for legal nerds, I guess, for attorneys, but it's actually funny because Wyoming, the statute that it says, the statute for the Wyoming LLC laws says, and this is important too, that no matter who is the owner, right, whether the owner is known or not, the statute literally states, hey, if the owner of a Wyoming LLC is sued, they cannot ever, no matter what, under any circumstances whatsoever, take anything that is owned by a Wyoming LLC. Hooray! That's awesome. And I'm only slightly paraphrasing here. But even more, though, even more important is Wyoming literally listed out things that have been done in other states to get liability out of LLCs, like foreclosure on an LLC or taking management control over the LLC or forced distributions of the assets, things like that. I bet you're going to be shocked to hear that those things have happened in California. But so then the Wyoming legislature literally listed out some of those things and said, hey, yeah, we know in other states foreclosure of an LLC has happened. Not here, cannot happen. We know in other states that forced distribution of assets has happened. Not here. We know that in other states management control, the plaintiff has taken management control over the LLC. Not here. And again, I'm only slightly paraphrasing. Like, it lists out other things that have happened in other states and says these things cannot happen in Wyoming. And so we really like using Wyoming for a parent company. Again, it's not a 100% rule, but if you're a real estate investor But if you're a real estate investor, then yeah, more than likely we'll have sort of Wyoming parent company that then owns local LLCs. And so then we get this going here that like, okay, I get the idea. So then a local LLC will own a piece of real estate. Let's not use California, for example, just because we talk about California a lot. I know Don's in Utah. I'm actually in Utah myself as well. So we may say Utah LLC or use some other random state. Well, let's go with Nebraska. I have a few clients investing in Nebraska right now. So we may have a Nebraska LLC that owns a piece of real estate for a rental property or a flip or something like that. And then we will say that Nebraska LLC should have a parent company. If it's a flip property, see on the right-hand side of the screen, it might be owned by a corporation for tax planning. But if it's a rental property, a long-term hold, it would be owned by a Wyoming LLC. The Nebraska LLC would be owned by a Wyoming LLC. This way, if there's ever a lawsuit, we don't have to rely on the relatively weaker laws of Nebraska or whatever other local state it may be. But instead, we will then have the local LLC point to a Wyoming LLC. I guess I should point down because that's what the structure said. So point to a Wyoming LLC that serves as the holding company and thus is going to drag any lawsuits that make it past the starting line to Wyoming. And I'm going to make one more point, and then we'll shift gears here to the statutory trust, and this will be important. All of this holds up in court, spectacularly so. It's also true, though, that most of the time, plaintiffs' attorneys don't even get that far. We take that logistical piece of it, right? I told you that logistics matter almost more than actual laws and statutes anymore. So we take that to your advantage and we say, hey, look, if an attorney if all they're thinking about is how much money they can make, well, guess what? If they can't find you at all, they don't think they're going to make any money. But if they do find you, if you're not anonymous, which happens sometimes, but they see a setup like this, with LLCs, with corporations, with statutory trusts, they don't care how good of a case their client has. They're not going to come. They settle with your insurance instead. And so it kind of alters the playing field. It's almost like playing an Uno reverse card, right? Reverse. Haha, I gotcha. That they say, okay, you only want to sue me because I'm wealthy. Well, haha, you can't have anything anyways, even if you win the lawsuit. Even if you win a judgment, like we've had them go this far where somebody has not only pursued the lawsuit, but they've won and they still can't collect because they have an entity structure like this, because the defendant has an entity structure like this. So now, to be sure, again, most plaintiffs won't go that far. They see the plaintiff's attorney sees an entity structure like this. They say, wow, that's going to be well over 6 figures in attorney fees, 3, 4, 5 years in court. And even if I win, I probably don't see a penny. Nah, and they move on and settle with your insurance. And that's what we want. That's what we're looking for. So I'm going to grab a couple of these questions really quick here. And some of this, and some of this is applicable. Some of them I'll brush on quickly just because, we want to stay relevant for the topic of our conversation today. So Alper cheated and did research ahead of time and is asking about the actual structure for an LLC. And a short answer, Alper, is that what you described is generally correct. Every entity structure will look a little different. But Alper is asking, so what we're looking at here is if you look at the 2 red boxes, when we structure a Wyoming statutory trust, very importantly, that statutory trust will have an LLC as the beneficiary. So you could almost, if you're looking at this structure on the left-hand side, replace those local LLCs with Wyoming statutory trust. And then their beneficiary, which is functionally the owner of the trust, not quite, but functionally speaking, will be a Wyoming LLC. That's how we usually set it up. I'll explain why here in just a second, but short answer for Alper there is that yes, you are correct here that's what we're looking at, that we want a Wyoming LLC to be the beneficiary of those statutory trusts. And Alper asks, can a Wyoming LLC be both the beneficiary and the trustee of a trust? Every trust needs a trustee. I'll explain about that in a second. The short answer is yeah, but it's not recommended that you have them both be the same thing. And so, yes, a Wyoming LLC can be referred to as a holding company. Absolutely. You can call it a holding company, a parent company, a shield, castle, whatever, umbrella sometimes, whatever other metaphor you want to use there. Yes, that's what the whole holding company is. So we may have, or we may choose to have a large number of LLCs. So you can see here, this local LLC could be replaced by an LLC oh, I don't know, Texas, in Maine, in New York, or in Oregon, or wherever else. We may say local LLC here, and then we may have another LLC in another state. We can have a number of LLCs, but then only one holding company, and that's intentional. That's intentional. That's what we want to see. Somebody asked, rightfully so, this is not the topic of our conversation today, but it's an understandable question. Somebody asked about the Corporate Transparency Act. Does that impact anonymity as far as having anonymous ownership of business entities? The answer is yes and no. And so I'm really sorry. That's a total attorney cop-out answer. So here, I'll explain. Does the Corporate Transparency Act impact your anonymity as far as plaintiffs go, as far as attorneys go, as far as the general public goes? No, it does not. The Corporate Transparency Act is a reporting mechanism to the government, and even then, not everybody in the government has access to those reports. So if we are filing a report for an LLC or a statutory trust or a corporation, those are kind of the big three for the Transparency Act, then what we're doing is we're sending this information to the government, but it's 100% private as far as anybody in the general public is concerned. It's like a tax return. Love him or hate him, Donald Trump is a good example of this, because Donald Trump's tax returns are not public, or at least they weren't for a long, long time. It took years in court to get even that considered to have his tax returns exposed to the public. Same thing goes with the information that is sent to the government for the Corporate Transparency Act ownership reporting. The government has said that they're keeping their database they're keeping their database as private as they would for tax returns, and that is not publicly accessible. So for a lot of people, that is comfort to know. In fact, it should be for everybody, right? It's not publicly accessible database. That's awesome. But the fact that the government still has this information can still be concerning in general for a lot of people, and that I understand. And at this point, because they say, I don't trust the government as far as I can throw it, reasonable. Or they may say because the database could be hacked, also possible, though frankly, I think the IRS's database would be a bigger target than the beneficial ownership reporting database. Just my 2 cents there. But yeah, totally. And so you're right. And to be clear as well, I think that the Corporate Transparency Act is utterly silly. It's overly burdensome and does not accomplish the goals it set out to do at all. But it's what we have to work with right now. So will we do reporting for your entity ownership if you sign up as a client for Anderson? Yes, we will. We will comply with the Corporate Transparency Act. Will it actually harm your anonymity or your protection in the long run? All signs point to no so far. So totally valid question there, and I wanted to get that out of the way. Good question here. Roger asks, can we put LLCs, can we put vehicles into statutory trust? The answer is generally no, for the same reason. Your insurance rates will skyrocket, and it brings liability to whatever other assets you have in the statutory trusts. So, and lastly, we have a question about if, let's say, we have a potential thing that will cause liability happen while I own a piece of property in my name, in my personal name. Can we hurry and change things up after the fact, but before court proceedings begin? The answer is most likely no, and that's why we want to make sure we plan ahead of time. Judges are hyper aware of this sort of thing of, oh my goodness, I may have caused liability. I'm going to hurry and transfer all of my assets out of my name as fast as I can. Ha, I got you. Can't do anything about it. Like if you cause a car accident, if you hit somebody with your car and then 3 days later, suddenly you own nothing. Wow, it all disappeared into a trust. Like judges know what happened. And the plaintiffs absolutely have the ability to say, no, we're going to look at these assets as they were owned at the time of the incident that caused liability. I realize that sentence is a mouthful, but basically, however you owned the assets at the time of the car accident or of the slip and fall or of the breach of contract or whatever else it might be, that's what the judge is going to look at. So totally understandable question, but that's why we want to plan ahead of time. So, and somebody asked, Carolyn, this is a perfect segue. So would we use a statutory trust instead of an LLC? Answer here is yes. In this structure, the statutory trust would replace these red boxes right here. So let's see, I can draw here. As you can see, so these red boxes would now be statutory trusts instead. And so I'm going to type that here and then draw a little arrow here. Look at me go. Oops, I just hit undo instead of draw a little arrow. How embarrassing. But you get the idea that a statutory trust that the statutory trust in this case would replace sort of those child or subsidiary LLCs that are owned by the Wyoming LLC. So now that we have this sort of baseline knowledge, oh boy, my little thing still showed up on the next slide. That's a little embarrassing. Let's go ahead and let's trash those. All right, perfect. Looking good. So when we talk about, okay, so why would we use, thank you for the laughy face. It was funny. So why would we use then a statutory trust? Well, there are different things in different states, and Don talked about this ahead of time. So if I'm recommending LLCs so wholeheartedly, and I do, why would we use a statutory trust in some different situations? So to be sure, one of the primary things is that California $800 franchise tax. It's a way to avoid the franchise tax. So just again, so we're all operating with the same knowledge here that California charges an $800 minimum tax for every LLC created in the state. But wait, there's more. It's not every LLC that's created in the state. It's every LLC that is created out of the state, but that is owned by a California resident. Isn't that wild? Isn't that wild? I could be a California resident. I own a property in Texas. It has Texas tenants. It makes Texas money, pays money to Texas cleaning services, and it has Texas marketing on the Texas lawn, everything Texas. But California says, yeah, you owe California taxes on that. Sorry. I have a colleague of mine, whose name is Josh. He and I we almost call it a podcast anymore every Tuesday morning at Anderson Advisors, and we joke that if you sneeze in the general direction of California, they'll try to tax that. And so what we do then is we say, okay, what do we do to avoid the franchise tax? Well, the statutory trust is it. And so we found just a little, and I'm going to give Clint Coons, who's one of our partners, all the credit in the world. Not like I would talk poorly about him, but he really did a great job with this, where he says, "Hey, what we would use is the statutory trust. Why? Because there has been guidance that has come out from the California Franchise Tax Board where they literally say, hey, we know that statutory trusts exist, but we are not going to tax them that $800 minimum or charge them the franchise tax at all. To be sure, it's $800 minimum. It could be more. But California has said, hey, we know that statutory trusts exist and we're not going to charge them this tax. And so where Clint's creativity came in is because statutory trusts, before we started using them here at Anderson, they were almost always used for really big and hyper complicated investments. Some of you may have heard of a Delaware statutory trust. Pardon. Where what that the one of the primary purposes of a Delaware statutory trust is to do some extremely, and this sounds negative, but it's just a matter of fact, some extremely convoluted 1031 exchanges where investors pool all their money together into an asset and then they want to 1031 exchange that asset that has like anywhere from 25 to 200 owners. Can you imagine how hard that gets? Well, the Delaware Statutory Trust makes it a little easier. So when the California Franchise Tax Board put out this letter ruling that said, hey, we're not going to franchise tax these huge complicated statutory trusts that are used to pool investment money together and do wild 1031 exchanges, that's what they had in mind. Is they say, yeah, look, we are aware that Delaware statutory trusts exist. We are aware that they are an investment vehicle that people use, but we're not going to charge the franchise tax to these Delaware statutory trusts. But importantly, they said statutory trusts in general and not just Delaware statutory trusts. And I apologize, this is getting to a little bit of the details, but I think it's fun to pull back the curtain a little bit and see how we arrived at this point. And so then Clint Coons and our other attorneys and CPAs in house, we kind of said, well, hey, look, So if statutory trusts aren't taxed by the Franchise Tax Board, what if we set up really, really, really simplified statutory trusts where it's not this huge complicated thing for these big pools of investors doing wild exchanges and things like that. But what if we just set it up for our clients? What if we set up a simplified statutory trust in Wyoming, maybe instead of in Delaware, where we have this and it's disregarded tax wise, so it's not going to be charged the corporate tax rate. But then we also say, wow, we also say, wow, it's a statutory trust, so it's not subject to the franchise tax. And that's kind of where we are now, is we say, okay, we set up for you, our clients, these statutory trusts that in their simple forms, not when they're not being used for these wild, super complicated exchanges and investment pools, but in their simplified form, just to hold real estate, they're functionally an LLC by a different name. And that's awesome. That's what we want because that gives you, again, same idea, awesome protection in court. And we use this and we rely on this that the Wyoming legislature, so that's that second little bar here on the screen, that the Wyoming legislature literally said, hey, Delaware has statutory trusts, we want to do one too. And so they go through and they create all the rules about it. And we make sure we follow them to a T. And when you do, Wyoming says, yeah, good luck trying to take anything out of this. And that's awesome. That's what we want. So that's what you get when you have a Wyoming statutory trust, is it provides a ton of protection and it provides that anonymous ownership. And it also very, very importantly avoids the California franchise tax. Now, to be sure, a lot of you are asking, well, I don't live or invest in California. Will this be useful for me? And I have two answers for this. First answer is, of course, yes, it can be. I add sort of that asterisk that we're not going to recommend a statutory trust in every situation. Like, no, they're a little expensive. They're a little more expensive than an LLC. So, and I'm not a used car salesman, right? So I'm not going to tell you you need one if you don't, but yeah, it can still absolutely be used outside of California. I'll give you a couple of other quick examples. Both Oregon and Arkansas have really weird rules of disclosure of ownership of LLCs. So for now, we have a really awesome, tight little loophole there that we can fit a Wyoming statutory trust into, where we may use a Wyoming statutory trust in Oregon or Arkansas or a couple of other states that have those disclosure rules, because they can still provide the protection of an LLC, but then we don't have those same disclosure rules in Oregon or Arkansas. Again, there are a couple of other states where this applies, but those are kind of the big ones that we see coming up regularly. So that's another example of where a statutory trust would apply. So that's my first answer to your question. Well, if I'm not investing in California, could this still apply to me? Absolutely. But two, my second answer to that question, again, completely understandable question, is okay, so if this doesn't apply to me, what will? And my answer will be, there may be a myriad of other things. This is something that is so detailed and so specific. It's us. We're the Anderson Business Advisors. We're the ones who use statutory trusts. And it's awesome. We love it. And we love that we do that. But this is certainly not the only hyper-specific strategy that we've come up with to avoid a negative externality from investing in a specific state. And I apologize, that sounds like I'm bragging. I am. If you'll forgive me, but it's really cool that we come up with these things and we have them for all 50 states where we need them. To be sure, a lot of states are pretty straightforward. And that's a thank you. That's a good thing. We should be grateful that investing in a lot of states is pretty straightforward. But if we have something else we need to worry about, we have workarounds. Julie asked a great question here. So what about Tennessee franchise and excise taxes? That's another incredibly specific strategy. It's mildly off topic, but I think it's a great example of something very similar to the Wyoming Statutory Trust, where Julie, to answer your question, do we have a way to get around that Tennessee franchise and excise tax? Answer is, yeah, we do. So what we do in Tennessee, though, is we don't use the statutory trust in Tennessee. What we have in Tennessee is called the FONCE exemption, family-owned non-corporate entity, FONCE. This is the FONCE exemption from the franchise and excise taxes. Why does that matter? Well, it matters because we can set up business entities. Somebody in here earlier mentioned mentioned series LLC, and that's a great example there. Is we can use a series LLC. We can use a really, really, really weird loophole. I actually kind of don't like it, but it works, so whatever, we'll go with it. We can use a really weird loophole with series LLCs to where we can claim that the series LLC has all the protection in the world of a Wyoming LLC if the Wyoming LLC is the parent company, but for the purpose of the Tennessee franchise and excise taxes, we can claim that the series LLC, this individual cells is what they're called, that they are owned by you personally, so that you are then a family-owned non-corporate entity that doesn't have to pay the franchise and excise taxes in Tennessee. And again, I realize that that's not really on the topic of statutory trusts, but it is on the topic of us showing that, we have done research in all of these states and we have come up with things. Now, to be sure, as Don said towards the beginning, does this mean that you sign up with Anderson Business Advisors and you'll never pay taxes again? No, not quite. But that we have things that we can talk about that will apply to your specific situation and it will be unique to you. What we're talking about are general strategies, right? But we have things that we can work with for just about anything. We've had tens of thousands of clients. And so do I still see things every now and then that I haven't seen before? Yeah. But because we have so much experience, and I want to be sure as well, a lot of this comes from our own investing experience, right? A lot of us are investors too, especially the partners. And so these things will come from our experience as investors and as attorneys and from having so many clients and seeing how these things work. And so the odds are really, really, really good that even if you have a really unique situation, we'll come up with something to help you out. No worries there. And so I apologize that that was tooting our horn for just a second there, but I think it's important to know that, yeah, we're aware of a lot of these state specific things. I'll jinx myself if I say all of them, but I'm very confident that we're aware of the most important ones, certainly, and that we can help you work with them. And I want to touch on lastly, there have been a couple of other questions that have come up, and so I want to make sure that we address them quickly. But I want to touch on one more thing here. If you look back on the slide here towards the bottom here, the last little bar there says nobody wants to mess with them. And this is alluding to what I've talked about a couple more times, where we are using these entities and these statutory trusts to provide protection for you, not just in the courtroom, though they do provide protection in the courtroom, but also in just the general logistics of lawsuits and liability. Is that, look, a plaintiff's attorney, especially personal injury attorney who's looking for a quick buck, first, they're going to have a hard time finding out who you are. But then second, if they see a statutory trust like this, like, no, they don't want to touch that with a 10-foot pole. Nobody wants to mess with them. Do you think that plaintiff's attorney wants to try to be the first one to go to Wyoming, take on a statutory trust and win? Like no, that could cost them easily one, two, $300,000 in attorney fees, and there's no guarantee they get it back. No way. And plaintiffs and personal injury attorneys, they're looking for the next big quick buck. And so they see something like this. No, 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 no. They don't want to mess with it. So I wanted to provide that as sort of a clarification there. And so yes, you ask, we talk about, like, can this save you money on taxes? The answer is absolutely. Can you imagine if you just have 3 or 4 properties? We'll use California as a specific example, but again, we have tax strategies that are similar to this all around. So can you imagine if you have 3 or 4 properties in California paying at least $2,400 per year in franchise tax fees, if not more than that, but you use a statutory trust and suddenly that becomes zero? What? Can you imagine how much money that saves you over time? I've got a client that has 9 properties in California. Can you imagine how much money this saves her every year? Not just every year, right? That's almost like that's $7,000, $8,000 a year in franchise taxes. But she's been a client of I've been working with her for about 4 years now. No, 3 years, 3 years now. Yeah, that's almost $20,000 in tax savings just right there, right? And so these kind of things, it makes a huge difference. And so I want to really emphasize that these are the kind of things that we work with when we talk with you. So that's what a Wyoming statutory trust is and how it works. Let me go ahead and address a few of the other quick questions that I have that have come up here. Yeah, so Teresa asks a good question on the topic of vehicles earlier in the conversation. So if I have vehicles that are pure business vehicles that I'm using for business, so let's say that you have a construction company, you buy a Dodge Ram 3500 to tow around a big trailer and a backhoe to different construction sites or construction materials or whatever else it might be. So it's being used 100% for business. Can that be owned by an LLC? The answer is yes, but it's 100% for business is the very important part of this. And so if it's owned 100% if it's used 100% for the business, can it be owned by a business? Yes, but we would still recommend that you have it in a separate business entity away from the one that is actually collecting income from your clients there. I can talk about that in detail another time. That's a great question. And so what we have here then, and let me go ahead and see. Yeah, absolutely. And so these are parts I already touched on. Sorry, I didn't bring up this slide earlier, but already the things that we have talked about there. So yeah, let me address a couple of the other questions here. So Simone asked, why not use a non-statutory trust as the set lure? So this brings up an important part that every trust, and we talk about this a little bit, but even though Wyoming statutory trusts they sort of fill this spot as an LLC or as the local LLC here instead. Every trust needs a trustee and a beneficiary. So instead of being the quote unquote owner of the trust, the Wyoming LLC is the beneficiary. It's functionally the same thing because the beneficiary is who is sued in the event of a lawsuit besides the trust itself. And so in this case, if somebody wants to sue a Wyoming statutory trust, they sue the trust and they sue the beneficiary. Well, guess what? Both of them are protected by Wyoming law. So good luck. And so Simone had asked, why not use something else as the grantor? The answer is hypothetically you could do that, but it really won't make a difference in court because the grantor is the least important thing as far as when we're analyzing who has liability. Who is the trustee and who is the beneficiary is going to be what matters when we're going to court. Totally valid question here, but it's not really going to make a huge difference who the grantor or the person creating the trust is. And so if you are creating a trust and you move properties into it, you are the grantor or the person creating the trust. Good question. And so let me go ahead and I've loved the questions we've had so far, and we've addressed a lot of good things. And so, rather than I had a whole segment, and we can talk about it. I'll be glad to talk about it for a little bit longer. I had a whole other thing I wanted to talk about briefly because we had had a couple people beforehand asking about some tax planning, and so I wanted to talk about some strategic tax planning outside of just using statutory trusts that we can talk about. However, we've had a bunch of really good questions, so I want to address those. So before I do that, though, I just want to say thank you, everybody, so much for joining us today here. Thank you to Don and the Protect Wealth team for having us. It is always, always, always a pleasure. So what we're going to do now is as a thank you for sharing this time with us, I want to send you. So I hope you'll forgive me as I grab it really quick. But I want to send you a link where you can have a free strategy session with us. So I'm going to send this over in the chat feature. So everybody take a look at the chat feature. It should pop up on your Zoom window here. And so what we're looking at there is as a thank you, click on that link to go ahead and sign up to have a free strategy session with one of us. You can talk with myself or any of my other outstanding colleagues. I'm very confident in my own abilities. That's also true that we have just a spectacular staff, and they do an awesome job here at Anderson Business Advisors. And so I wholeheartedly recommend anybody that you talk with here, if for whatever reason we are not able to speak together. So go ahead and click on that link, and you'll get us for 30 to 45 minutes, and we'll answer whatever questions you like as it relates to your personal questions and situations. So then we may say, hey, we can talk with you about whatever is on your mind related to your investments, related to your questions, your concerns, and your objectives in the future, right? It's not just bad things. We want to plan positively for the future. So click on that link and sign up, and we'd love to see you. Love to see you. And if you have a hard time with that link, I'll go ahead and shoot me an email. I'll send my email address, and you can go ahead and reach out directly to me as well. Though I will say that the quickest way and best way to make sure that we get you taken care of is to click on that link so we can have you go through there. So go ahead and click on that link, and we would love to talk with you. 30-minute consult there. So what I'm going to do here now is we'll be on for the next we'll call it 15 to 20 minutes here, and we'll answer a few other questions. I can jump in if you don't have other questions. I'll be happy to jump into some of that advanced tax planning stuff, right? But let me go ahead. I'm going to stop sharing this screen, and Don, if it's all right with you, what I'm going to do is I'm going to share a little whiteboard. Or can I do a whiteboard here? I think I can. Yeah, let's look at this. Boom, baby. All right. So I'm going to share a little whiteboard here where I can diagram out a few different things related to the questions that we have, coming on here. So let me go ahead and address a few of the other questions. Can a statutory trust be the majority shareholder in a C corporation? The answer is it can. But very importantly, if that C corporation is doing business in California, it's not going to avoid the franchise tax for active income. And that brings up a really good point. Somebody else asked, I think is Marty here. Somebody else asks, "Hey, I am an insurance advisor using a corporate, using California sole prop. Could I set up a statutory trust in California instead of using an LLC to avoid the $800 franchise tax?" That's a good question. And so I want to address both of these, the statutory trust for a C corporation and the sole prop. If we have active income, and so this is an important thing to think about here is if we have active income in the state of California. So we're talking about, for example, I let's just say I own a pizza parlor, right? Where I have a pizza parlor that ships in ingredients for my pizzas from California locations. My clients are California residents. They're paying me money in the state of California. My employees are California residents, right? And I'm renting out a building that's physically located in California. People using California roads, all those kind of things, and I'm gaining active income. And this is really important, is I'm gaining active income. I'm going to have a hard time claiming to California that I'm not subject to the franchise tax, if that makes sense. When we have passive income, when you are not actively doing business, but you just have a rental property that you are sitting on, or again, if we are in other states where we're looking to avoid dealing with reporting issues and we're using a statutory trust there, we have that argument, right? And that's why California Franchise Tax Board, they came out with that ruling forever ago, so several years ago, saying that these Delaware statutory trusts, pardon as I can get my hair, but they came out with that ruling saying that Delaware statutory trusts were not subject to the franchise tax. That was the big thing, is that Delaware statutory trusts were investment vehicles. They were not used, for example, to like open a Walmart that's doing active business in California. No, they were these Delaware statutory trusts that were the subject of this ruling from the California Franchise Tax Board. They were passive investment vehicles. And so then California said, hey, look, if this is a passive investment vehicle, we're not going to charge it the franchise tax, and it's not an LLC. So that's the kind of thing that we were looking at, and that's a great question. So that's a great question. And Carl asks, if I live in Tennessee, can I use a statutory trust? Yeah, you absolutely can. Though honestly, for you, again, and I want to be clear, as I said towards the beginning, a statutory trust is a pretty specialized strategy. It's not going to apply to everyone. Carl, if you live in Tennessee, we may not need a statutory trust. We could use other things instead. That's a great question. And yeah, it absolutely could hold title. So let's take a look at here. And so Alper asks a follow-up question here. So do we actually need two LLCs for statutory trust? The general answer is going to be yes. So I'm gonna draw the typical statutory trust setup here. And so watch me do this. Wyoming statutory trust, copy. All right. So let's say we have two statutory trusts, and they're both owned by a Wyoming LLC, or owned by the beneficiary of the statutory trust is each a Wyoming LLC. So we have here, I'll just use quick different colors so we can distinguish. But so then what happens is the beneficiary is a Wyoming LLC, and that Wyoming LLC then is what provides the ultimate protection for them. And we'll have our little arrows right here. Looking good. So yes, Alper asks, do we need another LLC to serve as the trustee? So in this case, the answer would be yes. What we may have is another LLC out here. I'm going to go ahead and change this. So we would say it's oh, it's not letting me type here. Hold on. So we may have another LLC over here. Oh, I see this one. This one is going to serve as the trustee for our that's going to serve as the trustee for our statutory trust. And the reason for this is a good question, is because the trustee will always be sued in a lawsuit. That's just how it is. And so the trustee, that's why I say the trustee and the beneficiary are who is most important in a statutory trust, because the trustee and the beneficiary will always be named in a lawsuit. So what we're looking at then is we may say the trustee LLC is going to be listed as the trustee of your statutory trusts. We want that because if you are listed as a trustee, then you will be sued in any lawsuit related to your real estate or your investments, whatever else it may be. But importantly as well, though, is if we name the trustee instead as the LLC as trustee, then the LLC is sued and not you personally. And that trustee, it's basically empty, right? It is empty. It doesn't hold any assets. It's just a scapegoat, an empty shell to serve as a placeholder as the trustee so that you are not there. And so, yeah, generally speaking, we will have a separate LLC that is a trustee to be named as trustee of your statutory trusts. Is that tedious and annoying? Yeah. Will it also provide excellent protection and save you just gobs of money on taxes in the long run if you're investing in one of these states? Also, yes. Also, yes. So both things can be true. Great question. So I have a question here. That's a good one here where Jeffrey asks, what if we use a non-grantor trust? That's a great question. So a grantor trust, importantly, means that the person who creates it has control over it. So the person who creates the trust has control over it because they are the trustee usually and the beneficiary. A non-grantor trust means that somebody else is in control. We don't really like that. That's how asset protection used to be before our limited liability companies, LLCs, caught on, is that in order to have asset protection, you had to pay somebody else to take care of your stuff. Honestly, it's no bueno. You have to, because what happens is then, conniving attorneys say, hey, you need this trust to provide asset protection. And oh, by the way, you have to pay me $350 an hour to manage all your assets because you cannot. Then what happens is then, you are not in control of your assets. If your attorney is on vacation and you need to hurry and do something because you're going to lose a deal, sorry. Oh, your attorney is not available because they're helping out another client and you're going to lose a big tax benefit, but they don't reply. Sorry. Or you want to sell your property, but your attorney suddenly cannot be found for whatever reason. Sorry. So that's one of the big things is we want you to be in control of your assets. I'm not going to charge you my hourly rate, which is just obscene with inflation. I simultaneously feel very confident in charging my $500 hourly rate, but I also hate that that's the going rate for a good business attorney right now. But yeah, so we're not going to charge you our hourly rates to manage your assets. That's why we want to keep these trusts with you in charge through a trustee LLC, as Alper pointed out. That's a great point. So then Hallie asks, if my car is held by an S corporation, is that recommended? Again, generally no. There are exceptions to that. There are exceptions to that if you're using the vehicle 100% for business and that S corporation is not where you are running your primary business. Now, of course, I would prefer if you do have a vehicle that you're putting into a business entity that we go ahead and we put it into an LLC that is either disregarded or taxed as a partnership instead rather than a corporation. All right, perfect. So Carolyn asked the question of, can you use a trust instead of an LLC here? And so what we're looking at there is the question of, can we use a trust instead of an LLC? The answer is sometimes yes, but it's not always necessary. And again, I want to be clear, statutory trusts, they are just outstanding, and they're just a super cool strategy that we came up with here at Anderson, the way that we use them. It's also true that I'm not going to sell you one for every single situation. They're more expensive. They're more complicated. Again, does it save you money and taxes in the long run? Of course it does. I told you about my client with 9 properties, right? She's saved gobs, just oodles of money using the statutory trust structure. But it's also sometimes more complicated and more expensive than using an LLC structure. So, Carolyn, we may end up just using an LLC where you are, or if you're or if we're in a different state, we may use something else instead, right? Somebody earlier, and I apologize that I didn't address this question directly, but asked about land trust versus statutory trust. Are they different? They are very different. Land trusts are a lot more simplified. They provide a lot less protection, but they're still very useful in other situations. So that's what it may end up looking like there, is we may use a land trust or an LLC or something else instead. Totally valid question there, though. And so Alper asks, and I want to I want to show this. So Alper asks here, what are we doing then? So we may say we have this entity structure here, and so then I'll draw a little dotted line that these statutory trusts have named the Wyoming LLC as a trustee. Wow, that's a hideous arrow, but you get the idea, right? You do get the idea, but now I want to erase it and do it again. So these statutory trusts then have the Wyoming LLC, this other Wyoming LLC named as the trustee. And so what we would do then is that this other Wyoming LLC, because Wyoming is anonymous ownership wise, we don't really need to worry about it bringing you any liability. So this Wyoming Trustee LLC, it's empty, doesn't pay any taxes, doesn't have any income. It's just a placeholder. And then it will go ahead and be disregarded to you. It will serve as the trustee, and again, you can just own it yourself. Again, because Wyoming is anonymous, we don't really have to worry about that. I'll add here, just because this was a topic of conversation at the beginning, let me add here a living trust here at the bottom, where as we talked about towards the beginning, the living trust will hold everything so that we avoid probate. Bada bing, bada boom, just like that. Look at that. So the living trust then, so this Wyoming LLC that owns your statutory trust or is the beneficiary of your statutory trust will then be owned by a living trust so that it can avoid probate. It and all of the assets that it owns can avoid probate after you pass away. So that's kind of what or after you pass away, pardon. So that's what we were looking at here. Anonymous asks a really great question, and this is something that we talk about related to California a lot. If I live in California, but I have a bunch of LLCs and properties in other states, am I still liable for the franchise tax? The answer is debatably no, but the franchise tax board is still going to try to charge you the franchise tax anyways. And honestly, it's less expensive just to pay the tax than to fight them. As I said earlier, if I'm a California resident, but I have a Wyoming LLC that has subsidiary or trialed LLCs, let's use a state we haven't used yet, in Ohio. In Ohio, I have subsidiary LLCs in Ohio that are making a bunch of rental money in Ohio. Again, from Ohio tenants using Ohio roads, using Ohio landscapers with Ohio money that does marketing on Ohio websites, like all of that kind of stuff. Yeah, of course, California still tries to tax it. Why? Because I live in California, and their claim is that because I live in California, even though I own assets out of state, those out of state assets are still doing business in California because I am a California resident. To be totally honest, that is constitutionally debatable. In fact, Toby, this was forever ago, so I don't want to give too many details because I'll probably get them a little wrong about the specifics. But broadly speaking, Toby challenged the California or Toby, one of our partners, Toby Mathis, challenged the franchise tax board on this, and he won, saying that yeah, you should not be allowed to tax out-of-state entities for this. But guess what? Then the franchise tax board just changed their own rules to give themselves permission to tax out-of-state entities. It was really silly. But the problem is that it's just cheaper for you and other investors to pay that franchise tax fee rather than to spend $25,000, $50,000, $75,000 in court fighting them on it. And California relies on that. They say, look, we know what we're doing is dubious at best, but we don't really care. We know no one's going to challenge us on it. And so then that's why we're forced to use kind of funny loopholes like this. I say funny, I think they're really cool, the statutory trust. So the answer for you, Anonymous, is yeah, if California finds out about your LLCs that are in other states, they will try to tax them, each one of them individually. So that's why we still recommend statutory trusts. And so for somebody who's investing out of state, we may have one statutory trust that's on the top here. So I'll diagram that out really quick, where we may say, hey, we have one statutory trust. I'm going to extend this out, but then move this arrow briefly. So we may have only one statutory trust that this one is not going to have. Oh, I somehow grabbed the wrong one, but you get the idea. We'll have another statutory trust here in the middle that serves as sort of a blocker entity, if you will. Think of like if you're familiar with sports, think of this as like a fullback in football. That their only job is to charge through the offensive line, find one of the defenders, and hit them so that the running back can can have a hole. Right. So you have the same idea here with this protector, Wyoming Statutory Trust in the middle. It makes it so that California doesn't find out, or at least it's much more difficult for them to find out about your out-of-state investments. So that's a great question, and that's what we would look at. That's what we would look at there. And so that's a great question, and that's sort of what this diagram is portraying here. So I don't want to keep you too long. Nobody wants to listen to an attorney any more than they have to. So I'll say thank you everybody so much for your questions. I'm going to rapid fire answer some of these, the rest of these ones. Then we'll go ahead. Please check out that link in the chat. We want to have that free 30-minute consult. I'll answer rapid fire answer a few of these other questions here so that we can wrap up here and not force you to listen to attorneys talk about boring legal jargon any more than you need to. So Mark asks, private letters, but letters, sorry, I apologize. I'm going to read the questions before saying anything out loud so I don't give away any personal information here. So if a property has a loan on it, can we still put it into a statutory trust? Short answer is yes, you can. If it is used as collateral in a loan, you bet you can still put it in a statutory trust. We do that all the time. That's awesome. What is the cost? Jeffrey asks. That's a great question, and Elvira asks the same question. I want to be clear about a couple of things. I want to be clear about a couple of things here. So cost, we work really hard to keep our costs down. So you most likely will never pay my hourly rate if you sign up with Anderson Business Advisors. We do flat fees instead. I just am a little hesitant to talk about what those flat fees are in front of everybody because they're going to, part of the awesome thing of customized plans is that everybody's going to look a little different. And that's intentional, right? We want it to be customized for your needs. It's also true that, hey, we are not going to, I don't want to quote you out here in front of everyone and then end up having your structure either cost more or less than that. I guess you wouldn't have a problem if it costs less, but I don't want to provide a quote here and then have that not be the case. So Jeff asks a question here. Hey, Don, are we saying here that irrevocable trusts are exempt from the CTA? The answer is kind of. Technically, trusts are exempt, but if we want to have any sort of actual protection benefit and you maintain control, we'll have to have LLCs or corporations somewhere in that structure, and then yes, those have to do beneficial ownership reporting. That's a good question.
Yeah, and I had answered that, and Jeffrey, the basic answer is if your entity is required to file an application with the Secretary of State. That would be LLCs, corporations, limited partnerships, statutory trusts. We file those by an application with the Secretary of State. Those are required that they file under CTAs. What's not required would be things that don't require an application. A land trust, a revocable living trust, those types of entities, because the applications are there is no application with the Secretary of State. Is that about as clear as I can? That's as clear as I can read the statute.
That's my understanding as well. Is if we're making an application or filing, it's going to report. That's exactly right. Great. And for now, we're hoping this changes, right? It's being challenged in court, but for now, our stance is that we have to comply. Like I said towards the beginning, it's not going to harm your protection or your anonymity, at least based on what we know right now.
The next summit, Clint and I will spend at least an hour between the two of us talking about the Corporate Transparency Act, and so we'll address that for you.
Absolutely, absolutely. Let me grab, I'm gonna grab Miller's Miller's couple of other quick questions here, Don. Just 30 less than 30 seconds. I'll let you go ahead here. So T Miller asks, what if there's a federal judge that decides to appoint a receiver, so like in a bankruptcy case or something like that? If it's a bankruptcy case, that might be a little different, but remember, or I should say remember, there's no reason for you to know this, but state law still applies over these LLCs. And so Wyoming law is going to apply no matter what. If we are in a situation though where let's say, for example, we have some sort of super higher liability because you did something criminal or something else like that, okay, no, the LLC is not going to protect you there. But the point is that, hey, if your assets are owned by a Wyoming LLC or by a Wyoming statutory trust, and we've done things properly, I do have to provide that caveat because there are things that you can do to ruin your protection. But if we've done things properly, you've maintained it properly, like Wyoming law is going to apply. That's just how it is. A receiver would be an extremely rare scenario and very extreme in and of itself. And then Teresa asks really quickly, if you own rentals in California but live in another state, do you have to pay the franchise tax? Generally speaking, yes, California will try to tax you, but again, that's where if you have rental properties, that's a great place where a statutory trust would come in and provide some protection there. Great question. And Don, I'll just say thank you again so much to everybody. Hey, give us a thumbs up or a round of applause or a heart if you liked our discussion tonight or liked what you heard. And we'll go ahead and we'll let Don take over here to wrap us up and bring us home.
Jeff, I absolutely appreciate this. My experience with the Franchise Tax Board has been is if you have a rental property, let's say in Tennessee, and you're sitting in California in your underwear at 3:00 in the morning thinking about your property, you have just crossed the line and you are doing business in California, and they owe you you owe them the $800 fee. It's a funny little law, but I love your answers because they're clear. It's a great workaround that's legal. We're not breaking any laws. There's nothing shady about using the laws that the state has created, but use them to your advantage. I appreciate that, Jeff. Thank you.
Absolutely, thank you again, Don, as well.
Strongly encourage you to take advantage of this. We can't make it easier. Sign up for a free consult, and that way they can apply the law to you and your situation, and maybe see if we can help you. We encourage you to do that. That link is in the chat screen. Sign up tonight if you would. Jeff, thank you for your time. You've been a master, a teacher. Thank you for that.
Hey,
Students, we
well,
appreciate you being on.
Pleasure to be here.
Okay. Thank you, and we'll see you in a couple of weeks with, I think Scott Estel is next up on taxes. I can't remember the topic, for heaven's sakes. It's a good one. Jeff, we'll see you, and hopefully we appreciate your help at the summits too. All right, everyone. Well. Have a great night, everyone. Good night.